Welcome back, everybody. This week we're going to talk about the legal issues in corporate investigations, and we certainly can't touch on every one of those, but there are a few court cases that I'd like to discuss with you, and we're part of the reading, and also some other rights and responsibilities that investigators and witnesses have. If you have not done the reading, though, please go back and start that now. And the reason I say that is because if you try to listen to the lecture without doing the cases, reading those cases first, you're not going to get much from it. It's going to be a little confusing for you. The quiz is a mix of the reading and the lecture, and you need to understand the reading, not just be able to quote it, not just be able to tell me what case had to do with what issue, but you'll need to be able to analyze the cases a bit to answer the quiz questions. So it's a little tougher of a quiz if you haven't done the work. If you've done the work, I suggest it's a breeze. Court case reading can be hard for some people. If you read it like a storybook, though, and just put that in your mind as you're reading a court case. And I took them, I think, all but one out of FindLaw, which is a pretty standard format, but they are all direct transcripts of the court cases, the decisions actually. Read them like a storybook, and they make more sense, I think. But if you've not done the reading, don't start to try to understand the lecture. Go back, come back tomorrow after you've done the reading, and pick up right here on the lecture. It's not an extremely long one, so go do the reading first. But let's do a bit of a recap. So we started out, we've got our investigator game faces on, right? We are cool, business-like, we are professional. We're not looking at this as, Elliot Stabler going to, slam somebody against the wall. We are a business person trying to get facts to support a matter to improve our business. We know the mission because we've got an investigative plan. We wrote that out. So we know what we have to do. We know what we have to prove, right? We have the tools to support our investigation questions. We know that we have those tools we discussed last week, and the ones that you made a great list of for the dossier too are all things you can use to help support your case. And we also understand something about interviews, not a lot, but enough to get by, and understand that these interviews are conversations. They're a conversation with a purpose and a conversation with a goal to get our investigative plan done and to find facts in a matter. But they are nothing more than conversations. And we know a few tactics to get to the truth, some of those pressure points that we can apply. And we also know that we don't know it all. And to try to learn investigations in a 15-week course is like taking a single physics course and expecting to go to a nuclear propulsion lab. It doesn't work that way. But this is a great beginning, I think, for you, a great survey course. So just understand that you got to know what you don't know. But we've gone pretty far now into this, and now we need to start talking about some of the limitations, and some of those limitations have to do with laws. So we all probably think of laws as the things you should and should not do, right? The rules about what you can't do or you'll get in trouble. But really, laws are put in place to protect people from people who would otherwise do them harm. The speed limit laws are put in effect so that you don't go too fast and kill yourself, right? And hurt other people, right? So they're really for the protection of others and yourself. But even the tax laws are meant to protect you, believe it or not, because they make sure that you pay the correct amount, what people tend to say your fair share of taxes, based on the laws. And law can come at you in several ways. It can be criminal law. You can't murder somebody. We have murder and manslaughter laws that say you can't do that and what the penalties would be if you're found guilty of that. We have administrative law, which are things like environmental laws, tax laws, things that administrative agencies of the government come back with, right? So the Department of Education says that you must repay your student loans, right? That's an administrative law. And then we have case law. Individual cases sometimes define the law. When a law is challenged in a case, then courts and judges will clarify that law, and in some cases, that clarification makes the law change ever so slightly. So case law is indeed the basis for much of the nuance of law we have. So if a law is challenged in court, and the court comes back, a court of authority comes back and says, okay, this is how we interpret this law now, then that interpretation becomes part of the law. It's case law. Laws change, it's very fluid, and there are many, many laws. You'll never really, even the best lawyers don't know them all. And so There are some tactics we'll talk about later to try to stay on top of them, but just understand that laws change, and so you have to stay relatively current on understanding which ones affect you, especially as a corporate investigator. So laws, especially a case law, can change very rapidly. Right now, there are many courts that are deciding cases. The Supreme Court decides some cases, but there are appeals courts and other lower courts that make case law. And they decide how a law is interpreted, and that indeed becomes the basis for the law. And it changes a lot, and it can change from one day to the next. And you have to also understand there's a downstream effect of legal change. By that, think about this. The Affordable Care Act, right, Obamacare, came in 2010, and it changed how Americans can access medical care. But it also changed the tax preparation industry, because if you've done your taxes since then, you have to provide information to show that you had medical coverage, because that was part of the law. So you had to, the whole tax preparation systems that places like H&R Block and others had in place to do taxes, they had to go into their software and make all kinds of changes to add in proof that you had coverage. And then there was another Supreme Court case that came and shot down the mandatory coverage, and therefore they could change it back, because now you don't have to provide that anymore. So the downstream effect of changes in the law, even though the law itself is still the same law, the way it's applied changed, and it changed a whole other industry. The American with Disabilities Act changed to give people with physical challenges access to buildings primarily, but it changed the construction industry. It used to be that you built a building and you had a grand staircase out front. That was something that architects would design, the constructors would construct it, and you had this great grand staircase on a really nice fancy building. But now you also had to consider you need a ramp, and you need elevators, and you need your doorknobs to be no more than 34 inches from the ground, and you need, there's a whole lot of changes that came in the construction industry. It was a downstream effect of the legal change. It just didn't change the law. It changed how people do things. The Elementary and Secondary Education Act of 1965 brought in federal funding toward public education. Before 1965, only local taxes were used to pay for school districts. So your high school that you went to was, if it was a public school, was funded by local taxes. Now it's a combination of local taxes and state money and federal money that comes in through the state. And that changed the textbook industry, because students in districts that had very little local financing, primarily in the U.S. South and Appalachia, now had this federal and state funding coming in that evened up the playing field somewhat on the cost per student, or the spend per student. And the textbook industry had to ramp up their entire industry to get ready for additional spending, because money was available for places that were using textbooks that were 30 years old. Another one that I thought of after I wrote this, and it's big for us, is the Fair Credit Reporting Act. The act that says how people can collect money and credit information on you if you don't pay your bills also affects private investigators. If a company uses an investigator that is not a direct employee of the company to do an investigation, they must tell someone if they become a suspect or subject of that investigation. That's part of the Fair Credit Reporting Act, which I'm not sure how it even links in, but a court case found that that is correct. Therefore, when you have certain investigations, you may want to think about whether you use a private firm to do those for you if you're not going to do them yourself. A lot of times you sub that work out. If there's too many investigations going on, you need help, you're not going to hire an investigator just to have the volume of cases go down again. You hire a contractor to do some cases for you. But if there are cases that are going to involve accusing someone, and they get to that point, from a legal perspective, they need to tell the person the minute they identify them as a suspect or subject in that investigation. So you may want to have that privatized service do legwork for you, but you remain the principal in the investigation that makes those decisions. So a lot of times there's a downstream effect of a law. And the reason I bring this up is that there could be a law totally unrelated to security that affects you, because there's this downstream effect of something like the Fair Credit Reporting that really had to do with collection services, impacting whether or not you could use a private investigative firm in a business setting. So big disclaimers on the fact that laws change, things change. Even some of the cases we'll talk about now could be overturned next week. So you just have to be able to have a way to stay as current as possible. So even though there are literally hundreds of things we could talk about that impact corporate investigations from a legal perspective, I'd like to concentrate on the Miranda rights, which those of you in criminal justice courses know what those are, and we'll go over that. Excessive conduct, coercion, searches, use of threats, and some tools as threats, what at-will employment is and is not, the Weingarten rights, which are part of the union interviews we talked about, and then unlawful detention, which goes beyond just investigations also into the private security realm in and of itself, but it's also a warning for investigators. So let's look at each one of those individually. So the Miranda rights stem from actually a series of cases. One of the defendants' name was Miranda, and these defendants were brought in, I believe, Arizona or New Mexico. And they were brought in for questioning, and they self-incriminated, but they did not know that they didn't have to do that. They assumed they had to answer all of the police questions without regard to the fact that they were incriminating themselves. And a court found that the police had a duty to warn people that they can remain silent, that they don't have to self-incriminate. And the whole basis of the Fifth Amendment was you don't have to self-incriminate. And the Miranda cases found that police had an obligation to warn people. That's where the whole you have the right to remain silent, the Miranda warning, comes from, right? But the Fifth Amendment requires that law enforcement officials advise suspects of their right to remain silent and obtain attorney during interrogations while in police custody. And therein lies the difference. That amendment is an admonition to government that they have the obligation to warn people. In a corporate investigation, you have no such obligation to warn people about self-incrimination. You only have the obligation to do an investigation in line with the proofs that we set up early in the course, right? Those seven tests, right? And to not coerce and not use threats and to get information from people. If you do that, you are legally allowed to ask questions that may include self-incrimination. But false promises, promises of leniency, if you cooperate with me, you get to keep your job. Unless you are the person that is allowed to make that decision, that is a false promise because you can't guarantee it. If you say, as long as you cooperate with me, you're going to get to keep your job, and the guy says, yeah, okay, well, I've been stealing from you for the last 20 years, and by the way, I raped somebody last week in the coat closet, and I've been actually tainting our products and putting poison in them, and a lot of people are going to die. You're bound by that. You're not going to lose your job comment. That's a bad thing. So that would be a false promise, right? Because in that case, the person isn't going to keep their job. You can't threaten them either. Everything must be free of coercion. That's the big thing from us. But we're not bound by those Miranda rights that police are. I myself do a warning in the beginning because I am bound by company policy that says that people must be truthful when they are part of a compliance investigation, which is what I do at compliance investigations because security is part of a compliance function. Excuse me. And it is in some form in most companies. So if you have a company rule that's written that says you must do it, then you should advise people of that so that they're aware that there's a rule that governs their behavior. That's the right thing to do. But you do not need to do the Miranda rights in a corporate investigation. So I think Addington versus Walmart stores of 2003, and that was an Arkansas case, Walmart being headquartered in Bentonville, Arkansas. If you've never been there, it's a beautiful part of the country, by the way, is really a textbook example of excessive conduct. The investigators from Walmart knew that there were people in their maintenance department that were stealing from Walmart, both maintenance items and store items, and they got a number of them to agree to search their homes, and one of them refused, and the Walmart people stayed at the person's home on the premises and basically harassed them into finally, after three times saying no, into saying yes. They had a police car parked in the driveway. Walmart claimed it was for their own protection, but it was really to coerce the person into thinking that if they didn't consent to the search, they were going to jail. There's no way that wasn't what it was used for. And so that type of conduct, that was really a threat and a coercion into agreeing to a search. The court did find the search was okay. But if you read that case, there were a lot of statements made by witnesses that were verbal and later refuted. So-and-so said this, but later denied they said it, which is really an admonition to any investigator to get everything in writing, get everybody to make a written statement, right? And even though the court supported Walmart in this case, one of the defendants, or one of the persons who was being accused of stealing things, David Clark, if you read the Lee case, which is referenced in Addington versus Walmart stores, he made a whole lot of money because the search of his home was coerced, in that he was told they were looking for stolen fishing gear, and then went through his home and found, I think, 400 different items of stolen property. But he thought they were only looking for one thing, and claims he was misled, and the court actually found in his favor in that regard. So excessive conduct really is about threats, right? When you're told, no, I don't want you to search, no, I don't want to talk to you, just go with the old saying, no is no. And, you can try to make sure that people are clear about what you're asking. But in this case, the person refused 3 times. The investigators never left the premises, stayed there, had a police car there to try to coerce the person. They were lucky they got away with it. In Arkansas, being rather conservative in this regard, sided with Walmart. They're a pretty powerful player in that state. But in the attached case of Lee, who is the sheriff, who was also misled, by the way, and became a plaintiff with Clark. They found that the investigators weren't truthful and did try to take more than they asked for, right, in their search, and therefore awarded Clark and Lee a substantial monetary gain. So in regard to searches, and this is searches of persons and their effects, People v. Volinsky from California in 1979 case, Zielinski was shopping in a store and was shoplifting. And she took numerous clothing items. And when she was caught, the store personnel, security personnel, asked her to empty her purse and personal effects, and found heroin on her person, and called the police and turned it over. And the state said this is a legal search because private security did the search. But indeed, they turned it over to the police, and because it was a criminal matter, the court reversed it and said, no, this became a criminal investigation at some point, and searching for heroin was not part of what was asked for. And so when you ask to search for stolen store property in a civil matter like this, where you weren't going to turn it over to the police, if you find illegal items, then the police need to get an independent search done, and an independent search warrant or consent to search. They can't simply go on the fact that you as a private entity conducted that search. So in this case, I think that there's also cases where especially in retail with shoplifting, where the police will come and be standing in the room when the private security person asks the person to empty their pockets, empty their purse, and the police watch. And the person, even though they're standing silently by and don't say anything, that is considered a police search, and a person has a right to deny consent to that search, and they have a right to seek an attorney in that case, and the police must get a warrant for that search if the person doesn't give consent. So having police stand by, just as we saw in the previous case, in the Addington case, is really not a great practice for any security function, any security investigation. Don't have the police in the room, don't have them standing by outside unless you suspect this person is going to become violent or do something to harm someone, because it is in and of itself a threatening situation. If you need to have the police present, or you need the police present for a case that you are working on, then give them the case. Make it a criminal case, wash your hands of it, give them the information that you have, and say, I'm turning this over as a complainant. I've done that in many cases, and you talk to the police and they're cool with it. It's not like they're going to roll their eyes at you or anything. This thing has gotten to a point where this is purely going to be a criminal matter. Firing the person is not just going to be the end of the story on this one. So it's become a criminal matter. I have several pending right now that we do the investigation, we find criminal activity, we know that we're going to take it criminal, and we turn it over to the police. But having the police stand by while you conduct the investigation using your internal, remember, Miranda rights. I don't tell people they have the right to remain silent, but if the police are listening in, would that not constitute something that required a Miranda warning? I would think so. So from that, learn from this case and the previous one, learn that having police stand by is a bad practice. And if it gets to that point, make it a police matter, turn it over and become a complainant. So the use of tools case, in this case, a voice print, right, was an Iowa case, 2001, Thiessen versus Covenant Medical Centers. Thiessen, ironically, was the security manager, and someone left an obscene phone call on an answering device at one of the hospital administrator's offices. She listened to it. She took it to her manager. Both of them agreed it sounded like Thiessen's voice. Thiessen was subsequently asked for a voice print sample so that they could confirm or deny whether it was him. And he stood on the contention that this was tantamount to a polygraph test because it was requested to verify truthfulness. And in the state of Iowa in 2001, polygraphs were considered to be illegal for either the engagement or the continuation of employment. So Thiessen claimed that a voice print was not something he was willing to provide. Thiessen was eventually put on a longer-term suspension while they tried to figure this out, and eventually brought in and fired for non-cooperation. The court sided with Covenant and said that this was proper, but there was a huge lesson kind of sunk in that case, and when you read it, you notice that Thiessen filed a suit claiming defamation of character. But indeed, it was Thiessen who brought all of this forward to newspapers that he'd been wrongfully discharged based on an Iowa law, that they couldn't request information. He made it all public and then claimed he'd been defamed. And that suit fell pretty much dead in its tracks because he's the one who brought this forward into the public eye. And the lesson for investigator is that if you don't keep confidentiality, you will be sued for defamation. And so if someone wants to talk about their case with others, you can tell them not to do that. In some cases, you can even fire them for doing that if they impede your investigation. But let them do that. Don't be the one who talks about a case. If you do that, then you could be sued for defamation, and that would stick. In the case of Thiessen, it didn't stick on Covenant because Covenant said, wait a minute, we've never brought this to the public attention. We've kept it private. It is Thiessen, indeed, who's filing the suit and brought it to the public attention. So the use of tools, you've got to be careful about what your state or your local laws may say about use of polygraphs. You can't threaten a polygraph in Iowa because you can't use one. So if you were to say, well, you're willing to take a polygraph on that, I suppose you could say that. The person could say no, and you couldn't hold it against them. But you couldn't say, we're going to give you a polygraph, because what you'd be saying is we're going to violate the law. So use of tools, make sure that any tool that you plan on using or you plan on mentioning to a suspect or subject is something that can legally be used in your jurisdiction. And most importantly, with this particular case, is that side lesson in that if they want to make this a public matter, you can't really stop that. But don't you make it a public matter of anything you find in an investigation, because defamation suit will follow and it will be successful. So one of the next concepts, and not a court case, but a concept, is that of at-will employment. And in the case of Thiessen, he was let go really as an at-will employee. And at-will employment laws are prevalent now, I believe, in 39 states, maybe even a few more. And basically what it says is that a company may release you from employment, absent an employment contract, for any reason or no reason. You could go to work tomorrow and your boss could say, I'm sorry, but you don't work here anymore. And you can say, but why? I do great work and I do everything you tell me to. I'm always on time. It doesn't matter. The company has decided that we no longer want to have you in our employ. We wish you well. That is what an at-will employment agreement is. It is prevalent in many states. And in some ways, there's a good basis for it, right? The basis, the argument for at-will employment is that it works both ways. I'm an at-will employee. The company may fire me at any time, but I also could quit at any time. And companies argued and made the argument stick in a legal sense that being an at-will employee means that you have choices and the company has choices, the same level playing field. That's a hard argument to argue against. I would also say, though, that most people won't quit their job unless they have someplace else to go, whereas the company can fire you and you don't have any place else to go. But it is a state law in many of our states that you are an at-will employee. Before you launch a full-blown investigation into something, that is normally a consideration. Is it cleaner if you kind of know, if you know that the person has had this type of behavior issue before, and you may have addressed it before? Do you need to do an investigation that final time when you know that, look, this is how it's going to turn out? Are you violating the 7 tests if you use at-will employment? And the answer is no. In some cases, you can simply say, you know what, this person's conduct, even if they didn't do it, their conduct is such that we just don't want them here. And the company can release that person without cause, without explanation. Once they give an explanation, then it becomes something that's challengeable. But if you just say, I'm sorry, we just decided that we don't want you working here anymore, and you walk them out at an at-will employment situation in most states, that is sufficient, and it's not challengeable, except if there is a contract of employment in place. Now, that does not mean that if you're a contractor, right? Because that's not a contract of employment between you and a location. That is between you, that is between your employer and that company they contract to. You're just a tool of that contract, if you will, right? You're something that's used to make that contract work. By an employment contract, I mean, in many cases, when you take a job with a company, they write you an employment contract. It is normally done in positions where you are paid partially in stock or in deferred income. So, you promise to work for me. I'm going to pay you X amount of money. I'm also going to give you, based on good performance, stock in the equivalent amount of 20% of salary. I'm going to defer income of $50,000, $60,000, $70,000 per year, put into a deferred account, which you will vest in 5 years from the day it's put in there. It's all golden handcuffs to get people to stay on a job, to not take the job and then leave right away, because a lot of your income, right, your compensation is put at some risk. So we'll pay you $100,000 a year, and we'll give you $50,000 in stock, and we'll give you another $50,000 a year, but we're going to put it into an account that you can't touch for 3 years. And if you leave, the stock and that deferred income go away. You get to keep your salary, but if you leave before 3 years, that other stuff goes away. You have a pretty good indication the person's going to stick around at least those 3 years. I mean, at some point, people do leave, and they leave stuff on the table. But if that's in an employment contract, then indeed that person has a contract, they are no longer an at-will employee. And one thing to really think about is this. I started my job 34 years ago with an employment contract. And that contract does not go away. So even though I work in an at-will state for an at-will employer, they would need to have some cause because I hold an employment contract. The at-will does not apply to those with employment contracts. And there are many of us out there. It was pretty common for people in certain levels of positions to have employment contracts, especially in the 80s, 90s, early 2000s. It's kind of gone away now. But you need to make sure that if you're investigating somebody or there's going to be an at-will decision, you should probably be asking, is there an employment contract in place? And you should reference that to see what the stipulations might be. So that's at-will employment in a nutshell. It seems relatively biased toward employers, that they can fire you without cause for any reason and just ask you to leave and you're done. But again, balance that out with the fact that you could do the same. You could call up and say, I'm not coming to work anymore, I quit. So there's, two-way street there. But also understand that you need to consider whether there's an employment contract sitting there from many decades ago that is still in force, because they don't normally expire until terminated by both parties. So again, make sure you check. But at-will employment may be an option for you to not investigate in some cases if it's just a cleaner way, and that's a decision made by your legal department and your HR department, but you should have that conversation in some of these investigations that you know how it's going to turn out. We all have those. Weingarten rights. We talked a little bit about this. It's the National Labor Relations Board versus Weingarten in 1975, and when it was determined by the NLRB that unionized employees are entitled to union representation at an interview when it comes to a corporate interview. You're not required to tell employees about that unless it's in your employee handbook or an internal policy. In your bargaining agreement, it may say that in the event of investigations, the investigator is bound or is required to advise the interviewee of their Weingarten rights. Very seldom does that happen anymore, that it goes in those types of agreements. However, you should understand that before a case ever comes up. If you're in a unionized environment, you need to read your union contract to understand whether there's any advisements that you need to make as an investigator should you get into an interview with a union employee. Now, as we learned, you can forego that interview. If you can do a thorough investigation without ever talking to that union person who insists they have a representative, then just say, okay, I'll go with what I know. I have enough. And just forego the interview. Or you can set up that seating arrangement and that raise your hand kind of practice we talked about, because the person doesn't have the right to interfere with the interview, only to be present during it. They could, at one point, speak up and say, I don't think you should answer any more questions, and that would probably end the interview. In fact, it should. But constant interruptions would not be acceptable. They sit back behind the person, tell them to raise their hand when they have a question, if you're going to have them there. But it is not required by law that you advise a union employee that they have the right to that union representation, unless you have it written somewhere else in your union agreement or in an employee handbook somewhere. Something as a security investigator you should be reading before you ever get to any of your cases. You should know all of your internal rules before you start. Great practice to have anyway. And finally, I'd like to talk about unlawful detention. The Meyer article on unlawful detention really talked more about security guards detaining people, but an investigator can do it just as easily. It's really associated with loss prevention. I mean, realistically. And you have a shoplifter and a store loss prevention officer and store management have the right to detain a person to confirm criminal activity. They can say, I need you to step over here into a back room. I need you to step to the side here. I need you to show me that you didn't steal something. You have a right to do that. Now, the person can flee that detention. I would not suggest anybody tackle them, right? I mean, those cases are plentiful in the courts, right? But if you have reasonable cause, you do have that right to detain for a short period of time to confirm criminal activity. But what's a short amount of time? The courts almost always side with the detainee. You got to do those things quick. You can't say, okay, sit here now, I'm going to call an investigator. He's going to be here in half an hour. You just wait. Never going to work. The key is ensuring you never imply custody as an investigator. Even though we want that person not facing the door, we want them to feel like they need to be there with us, that they really shouldn't go anywhere. You cannot imply that they are there and they can't go anywhere else. If they say, I'm done with this interview, I'm leaving, you just stop. You let them get up and you let them walk away. Now, you can go back then and say they didn't cooperate with my investigation. They can't stay in the workplace. And your HR person is likely to side with you on that, and they'll be removed from the workplace pending further investigation as to whether or not their employment is continued based on their conduct. But never say, no, you can't walk out that door. Huge for an investigator to understand that even though you want to in some ways imply that this conversation is going to continue, if the person says, no, I'm done, then they are indeed done, and you can't keep them in that room, even with the same regard that you can keep someone who has shoplifted. If you think about someone who's shoplifted, the store can say, we need you to stay here so we can confirm that there's been no criminal activity. Could you please open your purse or open your coat for me or whatever to check and see where the item might be if it's been detected that there's reasonable cause. But as an investigator, that part has already sailed. You've already got them to the point where you're bringing them in for the interview. You're calling them in. You can't imply that is indeed a custody. And as an investigator in the future, you may train other investigators. Make sure that they understand that that training on detention is part of that, and that it is documented, that they understand they cannot imply custody in an interview. Read that Meyer article again and keep it, because as a security professional, you will also have security officers working for you. Those rules are really the ones that get broken and come back to haunt you the most. So make sure that you understand it, and you set up a training program so that your officers understand it as well. So the big question is, with all of these changes and just these few laws we've talked about, and if you think about the number of laws and cases on the books, we have not touched on 1/1000th of 1% of the cases out there. So how do you stay current? Well, there's industry organizations that provide legal briefs, and you should attend those. ASIS International is one for security professionals. They do it even in their monthly news magazine that they put out. There's a section on legal briefs. You should read those. And the Society for Human Resources Management is a fantastic one, because much of the security, corporate security investigations laws come out of employment law, and employment law really falls a lot to human resources. So a SHRM membership, if your company allows you to have such a membership, I strongly encourage you to get one, as I have. Because their legal briefs, they do usually quarterly. They'll bring in a legal team to update you on employment law changes. And first off, they're extremely interesting. Second off, it really affects what you do as an investigator. But also have a pre-established relationship with your human resources and your employment law partner at your firm, because they will be able to help guide you. When you have a case, you can go to them and say, this is what I'm working on. What should I be worried about? What should I be looking for? What are the legal ramifications here? And don't try to have that relationship start when you're asking that question. Form those relationships early. And also don't limit yourself to security-centric advances in the law and changes in the law. A safety law change may impact you. Again, that downstream stuff. And look, don't kid yourself thinking you're going to stay current on every law that applies to you. You've got to make your best effort. You've got to show that you are taking those efforts to stay current. It's your only defense if indeed you find that you overstep. So staying current and showing you're trying to stay current is hugely important for the investigator. I encourage you to look at those organizations, ASIS especially, and Society for Human Resources Management, as two really good places to look for legal updates that impact the investigative space. So takeaways. Laws change and you need to stay up on them, and they change a lot. And staying up on them is tough. Having a good employment lawyer that you can talk to, and I have several, knowing who they are ahead of time, meeting them ahead of time, having them understand what your role is and what your experience is key to them keeping you up to date. The Miranda Zelinsky cases, those really are speed traps. They were cases that told police that they'd overstepped. And we use those as red flags for us, so that as investigators we understand when police are told they can't do something, we need to be circumspect and say, are we doing something similar, and does this affect us? Detention, and unlawful detention and custody is really in the eyes of the beholder. If they feel like they are being detained, then they are being detained. And you need to make sure that any actions you or your investigators take, don't make it very clear that this is not a custodial interview, that we appreciate you coming in for the interview. I don't normally say you can leave at any time, because I think that just plants the seed. But it doesn't mean that I don't mean that. And if they say, I'm done, I don't want this anymore, I'm leaving, okay, because you're not being detained, you are not in custody. An at-will employment agreement can be your friend, but make sure it applies. And this is really a discussion for HR and other decision makers. Do you want me to investigate this? Or is this an at-will situation where we're just going to part ways with this person no matter how it turns out? And maybe we just, cut to the chase. That, again, is not your decision, but it is something that could happen. And you want to have a conversation before you start an investigation with the HR partner, so that you don't find things that then now you need to give an excuse and you've opened yourself up to that lawsuit. Always weigh your conduct against the golden rule. Would you want this to be the way you were treated if you were under investigation? Is it better to lose the case or lose your credibility? Right? If you try to go outside the legal limits, you will lose your credibility. In some cases, the law may constrain you to the point where you just don't get to where you want to be at the end of that matter, and you don't get the right answer, and it's a cold case and it just falls to the wayside. It remains unsolved. Better to have that than to lose your credibility. Make sure you're always acting within the law. So there's a lot of reading for this week, as you know, because you've already done it, because you wouldn't come to the lecture without doing the reading first. But I think reading court cases can be fun. It actually becomes fun. I will be teaching security law in future semester, and you may see some of these cases again if you end up taking that course, because they are very germane to the subject. But I like reading court cases and preparing a brief from them. I hope you found that to be enjoyable, actually. Lecture work done now. Thank you for your attention. There is a quiz on this unit. It is due on Sunday. I also want you to start to reflect on the course a little bit, because your final is going to include, maybe not limited to, a reflection paper for those who have had me before. Start to think about what parts you liked, what parts you didn't like, and what I can do better next time when I teach this course, what you think might improve it. Those are all things that will be part of that paper. So I'd like you to just start thinking about those now as we're getting a little closer to the end of the course, because I believe that the final is about a month out. And so, it's time now to start getting into that finals mode, right? You want to finish strong. Been an odd semester for many of us, so let's make the best of it and get our best grades out of it. Reach out if you need anything. Start thinking about the course. Finish your quiz by Sunday. With that, have a great week, and I will see you on campus.